This hearing changes direction before either side even argues the merits, and that matters more than most people realize. The discovery that public assistance is still active instantly pulls state interests into what looked like a straightforward financial dispute. That forces everyone to stop arguing emotion and start dealing with statutory limits.
You looking that up?
Your Honor, I do have that amount. It's $706 per month.
Okay. So basically, and if I understand correctly, the mother can either get current child support going forward and whatever it is, or the TANF and the state gets the current child support.
That is mostly correct, Your Honor. There is a $50 pass-through, it's called, and so she would receive $50 of the transfer payment on top of her TANF, and not the transfer payment.
Or
however,
yeah.
If the transfer payment is higher than the TANF amount, she can close her TANF and receive the transfer payment because that would be more beneficial. However, I just printed these documents off of Odyssey, so the only objection that I know I have right now is the residential credit. I haven't had a chance to really review. I was just reading the financial declaration that was provided by Mr. Huberto.
And Your Honor, the numbers would not be more than whatever. If it's 706, the child support proposal would be far less than 706. So I leave that to Your Honor how you want to handle it, but I'm not sure the inner workings between TANF and a court order. If a court order is issued for child support being less than that figure, I don't know how the state can then pay extra to mom and expect my client to be reimbursed. So, but again, I've never had that issue come up. Ms. Maggart may have, Your Honor may have, but that's our concern.
What happens is it's under the statute, there can be no residential credit if TANF's being paid. Unless you know of a case.
No, I don't. I've never had an issue. So what is my client's ability to challenge the TANF being paid, right? I mean, that seems very, it certainly violates due process. There are certain things that come to mind. I mean, it seems ridiculous to me, but.
So what I can tell you is this: if we need to continue this a couple weeks for you guys to see if you can either A, reach an agreement, or B, research and get something in. The court's understanding and the statute is, and there's case law that's pretty clear, but I'm not saying that there isn't something else out there, that just came down or something. But residential credits aren't allowed if TANF is being paid. So I understand if you're going to argue that you want a residential credit, Mr. Huberto, probably need to continue this. And
we could, maybe, Your Honor, but I mean, for today, my argument's going to be, quite frankly, that the overall, the issue is there's payment of bills, alimony, and child support all thrown into one, right? So whether you give a residential credit or we argue an offset on whatever the bills are, we can proceed today. I think all the numbers are in the same pool and the same pie of funds that these parties have. So if mom's choosing to take money from the state and my client's potentially, sounds like, going to have to be reimbursing that funds, that's something that needs to be accounted from the court on what bills get paid. So if we have the number, I suspect I've done enough hearings with Your Honor, you can probably make an educated ruling based upon those.
Mr. Swenson, you good with going forward and dealing with the financials? It's a temporary order, so it can always be revisited if we get, more information down the road.
Yes, Your Honor, we're good with moving forward on the financial piece.
All right. So I'll hear from the parties. It's your motion, Mr. Swenson. So.
Thank you, Your Honor. We are here, Your Honor, because the other party simply chooses not to make the community funds available to Ms. Wilson. It was expressed in her declaration, and we filed some exhibits along with her declaration showing that when the money comes into the bank account, it immediately leaves the bank account. And so Ms. Wilson doesn't have access to it. We can appreciate the fact that Mr. Wilson is paying the bills, yes, but Ms. Wilson also needs to live outside of those bills, everything from getting things for the kids, to haircuts, to paying for new glasses, whatever she needs to, and she's not asking. And I realize we asked for 5,000 in spousal support and maintenance, and I realize after getting the financials from Mr. Wilson that may not be practical. But what is practical is just leaving money in there so Miss Wilson can reasonably use it, which was ordered by the court in April and shouldn't really be an issue, but that's why we're here. And if we look at Mr. Wilson's declaration, he clearly believes that Miss Wilson is not entitled to any of the community funds, which is incorrect. He simply states that it's his money in his declaration, that it's not our money, and that is just incorrect. Miss Wilson is not looking to buy a new house. She's not looking to buy a boat. She just wants to live in the same way that she was living before that. And so, again, we realize the 5,000 may be a little much, and we wouldn't even need to ask for spousal support if she had access to the funds, so she could.
The mother's presentation focuses on access instead of entitlement, and that is a calculated choice. Rather than arguing that the father has unlimited resources, counsel frames the dispute around everyday survival and practical needs. That approach attempts to make the request sound reasonable, even after acknowledging that the original maintenance demand may be unrealistic.
Just support herself during this process. And so that's clear under the statute that it's allowable. I don't know if the court wants me to go into the factors, the 5 factors, but I'm sure the court knows them. And the parties were married for almost 16 years. And again, all she wants to do is live per the lifestyle that she had. And if the court could order him to keep that money in the joint account, that would be all that Miss Wilson needs to keep living, Your Honor. So I don't want to go too far into it, but I think the court can appreciate the situation. And so pending any questions from the court, that's all I have, Your Honor.
Okay. Mr. Huberto?
Thank you, Your Honor. For the record, my client's present in a conference room in my office, but he's in the federal room. He's present listening. And I can see by the look on his face, some of this is somewhat confusing to him, and I don't blame him. It is confusing. We learned this, we're just lacking so much information, right? My client is under the belief at the time he's preparing his declaration that, hey, TANF is on hold. He's not going to have to pay that back. That it tells me that it's not ongoing. So, of course, I don't file my responses and provide them to the state. We learned this morning that, in fact, no, Miss Wilson's getting TANF. I really have issue with the process and how this is approved. But I guess that's nothing Your Honor can deal with today, and I certainly can't research it. But it just baffles me that one party can say, hey, state, give me taxpayer dollars, and then make my ex-husband pay for it. And at the same time, I'm going to go ask for additional support of $5,000 a month and a 50-50 parenting plan says. And it's even worse than a 50-50 parenting plan because, yes, they have weekly rotations, but they're sharing the house. So it's my client's paying for everything. To be clear, and for the record, my client, the parties have a parenting plan on April 24, 26. It says it's a 50-50 weekly rotations, but Your Honor did the old Judge Spurline and Antos thing where they rotate the house. And I understood the reasoning why, and I'm not challenging that reasoning, nor can we today. It's not before the court. So mom's living in the house 1 week, dad's living in 1 week, and the kids stay there, and it's been working for the last few months. So, and that's what they've been doing. We haven't come to court to address financial issues until now because my client's been paying for everything. He was the breadwinner in the family. He understood his role and his requirement to make sure that these household bills are made. So he's been doing everything to live dirt poor to make sure that the home mortgage is paid. Mom's car payment was paid. He's still paying for groceries for the kids, his own rent. He's doing all these things that are above and beyond. And then he gets this motion from mom that says, hey, I want $5,000. There's really no basis in mom's documents. There's no evidence. There's no financial declaration. There's no child support worksheets. There's really nothing. My client comes to the table in response, files worksheets, proposed order, because if she's asking for child support's going to get entered. So my client addresses that and provides his income. He provides his pay stubs, last couple years tax returns, and so on, explains the differences. I think the biggest nuance in the tax return is the year before, it shows significant more money than what he has now, and that was because he got a $40,000 relocation allowance. from work. So $40,000 is a significant sum in financials that he's not. It doesn't have accessible now, so that needs to be addressed, and that's why he pointed it out. So looking at these new numbers, I'm just getting right to it. From hearing from Ms. Maggard that Ms. Wilson gets $706 a month, she gets even more than we thought. I came in here today ready to argue that, hey, if Ms. Wilson even gets a minimum wage job, she has more money than my client after he pays all the bills, right? That's just minimum wage. Now, apparently, she gets a minimum wage job plus $706 a month in TANF benefits. That then is going to be further reducing my client's income because he's going to have to reimburse $706 to the state here in the future. So doing the numbers, the standard calculation on our worksheets is $1,498, so roughly $1,500. Now we understand Your Honor is not allowed to give a deviation. The standard calculation presumably is going to be $1,500 a month that my client's going to have to pay. So he pays $1,500 a month. He pays $2,900 for a mortgage for a home that she's benefiting 50% of the time, and then $600 for utilities. That puts him about $5,000 a month in stuff that he's just paying to mom. All the while, he has 50% of the time he's got to support these two kids and live his own, work full time. He has $6,700 a month net, so he will have $1,700 a month to live off. I mean, it's gas, food, clothing, you name it, not him and the kids, right? So that's $1,700 a month. He just can't do it. All the while, on the flip side, mom's going to get the home paid for, utilities paid for, and $1,500 on top of it before she's not working. The umbrage I take with mom's stuff is we didn't get a reply. We didn't get a reply that says, hey, this is what I've been doing for work, right? She asked for all this money, and I think she gives kind of a conclusory statement in her motion that says, I haven't been able to find work. Okay, great. Where have you applied for? Where have you looked for work? I mean, I find it hard to believe that after 6 months of separation, she can't find a minimum wage paying job, or certainly better given her background. But has she even tried? We haven't seen any of that stuff. She could easily, in a reply declaration, says, hey, I applied to Walmart, I applied to McDonald's, I applied to Confluence, Samaritan, whatever it might be. We got none of that because my client believes she hasn't paid those efforts. And quite frankly, she's the one who's asked for this divorce. They're moving, they're separating going forward. It's a reality. They are going to have separate expenses. She's going to have to find a way to move forward and get some income into the household. My client just doesn't have the funds. I said $1,700 a month to live off of after she gets.
The father's attorney takes the opposite path by burying the emotional argument beneath documentation and arithmetic. Instead of attacking the mother's character, he repeatedly returns to numbers because numbers are harder to dismiss than opinions.
Thousands, and this is without her having a job. So I think knowing this, if the standard calculation is going to be $1,500 a month, we need to address the payment of the bills. And quite frankly, she needs to take some of that money to contribute, not just her car payment, maybe contribute to some of the mortgage. So ultimately, in the long run, these parties probably need to sell this home, get out from under of it, help both of them move on with getting their own living expenses going forward. But of course, we can't do that on temporary orders, and we're not in mediation yet. So, but that's the issue. There just isn't any money to go around. So we're asking Your Honor to, I guess, order the standard calculation for the new information we find today, and then make mom contribute some of that towards the mortgage. I'm happy to answer any of Your Honor's questions, but I think that's about all we can do. If we look at the numbers, that the evidence before the court, that's all we have. He has $6,700 a month to live off of. We know the mortgage is $2,900. Standard calculation $15. Utilities $600, and that's utilities for the home she's living in. So I think we'll rest on those numbers, and hopefully Your Honor will come up with something that solves this, because I can't think of it other than that.
Okay, thank you, Mr. Huberto. Ms. Maggard?
Thank you, Your Honor. I was just checking with the DSHS website to determine if there was reported income to DSHS when obtaining TANF. I have not been able to locate that information yet. However, if the standard calculation is adopted at $1,500, I believe that would disqualify Ms. Wilson from receiving TANF. So that would, in essence, take care of the residential credit portion. If the $1,498, I believe it is ordered, then she would no longer be receiving TANF. There would just be a judgment that's owed for the back TANF. However, the state would also be cognizant of the expenses that the husband has been paying in this matter and would set the judgment at a reasonable payment, even as little as $50 per month to repay that debt. I don't believe that interest is collected, and so it wouldn't do any good to set it higher for him if he's going to have such a large child support order. But the state has no objection to entering a temporary order today, so long as we address that back TANF debt in the final order. Also, TANF is established by DSHS, not the Division of Child Support. So I understand Mr. Huberto's argument regarding due process. This issue does come up in 50-50 parenting plan cases. And it is unfortunate because it is whichever parent gets to the DSHS office first gets the TANF. And I don't have any control over that. But I do understand the frustration that it creates for parties because they are not necessarily aware that the other party has applied for TANF and it's a 50-50. So they're equally responsible for the children.
Okay, thanks.
Your Honor, if I could reply real quickly.
Yeah.
I will keep it brief. So, counsel in the end states, well, he doesn't have a whole lot to live off. He just has $1,700, but Miss Wilson has none. And there's a lot of discussion around the primary issue, which is if Mr. Wilson would have just maintained, like the court ordered, not to move property, including the money, we wouldn't have to be here. And Miss Wilson gets, aside from the TANF, she gets nothing from the community funds to live off. And so if Mr. Wilson would have just left things as is and allow Miss Wilson to dip into the community funds when needed, we wouldn't have an issue. I also find it hard to believe that Mr. Wilson spends $1,500 a month on groceries and eating out when he's got the kids part-time. And Miss Wilson is trying to find a job. It's a small community. She hasn't worked in 5 or 6 years, so it's going to take some time. And so Your Honor, if he would have not moved the funds against the court order, then we wouldn't have to be here. But we are, and so at a minimum, she needs access to that, and he needs to stop moving it. Thank you, Your Honor.
Your Honor, if I could say 2 comments. I know you want to roll on. First of all, I appreciate Ms. Maggard. I know my tone sometimes is frustrated because this is new this morning, but I understand it's not Ms. Maggard's fault. And if anything, she's being very accommodating to everybody to allow us to have this hearing today and not have to come back and incur additional attorney's fees. So appreciate that. And I also think the explanation of whether or not he can pay back 50 months, I expect Ms. Maggard to be reasonable. She always has been, and $50 a month with no interest is probably something that he'll avail himself of and make work. But it's still going to be a sum of money that he doesn't have in his pocket. So it's like if I rack up a credit card bill for $10,000, yeah, I could pay $50 a month, but it still exists as $10,000 is eventually going to get paid. So I think that's something important to take into account, that at some point he's going to have to pay that. So as far as the community funds, they're not community funds. I mean, they're separated like it's a client's income. I mean, it's not. If he allowed Ms. Wilson to continue to have access to the joint bank account that only consists of his wages, he would not have the money to be able to pay these monthly bills that he's been paying. So, anyways, again, happy to answer any of your Honor's questions. And Ms. Maggard, lastly, thank you again for letting us move forward today, even though it's not our motion.
The state's participation quietly becomes one of the most influential moments in the hearing because it removes speculation from the discussion. Instead of debating hypothetical benefit rules, the court receives direct clarification about how public assistance actually interacts with child support.
You're welcome, Mr. Huberto. If I may interrupt, I do have some additional information for the parties that may be relevant. The mother is also receiving $635 per month in food stamps.
Thank you.
Okay. All right. So there's a couple things going on here. Both sides use some terms that I don't want to say they're throwing them around loosely, but I think they're throwing them around in a way that is beneficial to their side. Mr. Swenson keeps on talking about community funds, and it's true. Earnings during the marriage are community funds. Assets acquired during marriage are community assets. And if there was a bank account that had $20,000 in it on the date of separation, then that's community funds. Mr. Huberto likes to talk about separate funds. The earnings of my client are separate funds. That's true for the purposes of, after the date of separation. But, again, before the date of separation, those earnings that might have been put away somewhere in a savings account are community funds until the date of separation. And so both counsel are correct in some of their assertions. And at the end of the day, it's going to depend a little bit on where stuff is. So Mr. Swenson, as far as, if there were bank accounts that had community funds in them, even if they originated from earnings, if Mr. Wilson moved them, took them, did stuff with them, he'll have to account for them. And, but by the same token, if they're earnings after the fact, like what he's making right now, is arguably separate funds. Now, the kicker to all this is all funds are before the court, and both parties have a duty to support each other while they're married. So the statutory factors for maintenance that exist for permanent maintenance after trial, that's contractually and put in court orders, but it's the same factors for pre-divorce maintenance, with the caveat that both parties have a duty to support each other. So at the end of the day, this is a rather, let me start with this. Right now, RCW 2619-075, subparagraph, whatever it is, D, I think it's 1D, is the residential schedule, and it talks about a deviation, and it specifically says the court may not deviate. And then it says if there's not enough funds, or if the child is receiving temporary assistance for needy families, TANF. So the court, and there's case law that talks about that, and I'm unaware of any other case law, and I think Mr. Huberto is kind of conceding that. Although the case out there, bring it up and the court will look at it. I don't have a problem. So if I start first with child support, I will set child support at the amounts. It's a temporary order. I'll use Mr. Huberto's child support figures. It's $1,478 or whatever it comes out to. $1,498. Basically $1,500. Just shy. $1.90 shy of $1,500. And I'm going to enter that order. Now, that's money that's available to the mom, and it's money that's not available to the dad. He has to pay it. And this is a 50-50 plan. And so when I look at everything else, when you look at the other factors, that leads the court to believe I'm not going to enter any other maintenance, Mr. Swenson. I can't. Dad's going to not have the funds to be able to pay any other maintenance. The real crux of the matter here comes down to what, if anything, does mom have to help contribute? And there's a couple factors going into play here. Mom does have a need to get a job. She's going to need to get a job, and she's known about it for a little bit, and she's going to have to get a little fire lit under her to do a little more of got to have a little more impetus to do it. So, Mr. Swenson, I'm going to rely on you to make sure she knows it's not just, she needs to be out when she doesn't have the kids for the week. She needs to be out. That's her full-time job, is finding a job. But in the meantime, again, both parties have a duty to support each other. So my one question I have, and I did not look at this, and counsel can maybe help the court.
The judge separates legal terminology from legal reality. Both attorneys use phrases that technically support their clients, but the court refuses to let labels decide the outcome. Instead, the judge explains that context determines whether money should be viewed as community property, separate earnings, or part of broader support obligations.
What are the vehicles that each party has, and what are the payments on those vehicles?
Your Honor, I can answer that for you. My client's vehicle, in fact, I believe my client does, the payment is on mom's vehicle. Is that correct, Mr. Wilson? You can nod your head, correct? The automobile
Yes,
bill
cool.
payment. The automobile payment is $443 a month.
Okay.
Plus insurance and
Plus
registration.
insurance. Yeah.
No, but I'm just saying the only.
But that's only for mom's vehicle. That's only for the Sienna. Is all I was asking, Mr. Wilson, correct?
Correct. Yes, there is no payment on the 2005 Chevy Trailblazer.
So he drives a 21-year-old car, so it's been paid for. Probably not worth much, but the Sienna is $443 a month.
And that's the only payment that's a vehicle payment that the parties have. They don't have any
Correct.
other. They don't have a boat or anything like that. That's
no, that's it. And also, one last thing to clarify, Your Honor, there wasn't any community fund. So all my clients taken off is he stopped depositing his current wages. To answer your first question, there wasn't like bank account monies that he had gone with. It just his current wages no longer get direct deposited.
sure. And it wasn't really a question. It was just a kind of a statement.
Okay, fair enough.
Their own spin on it the best way possible. For all, yes, there is no bank account with $50,000 that they had saved during the marriage, or maybe there was. I'm not saying there is or there isn't.
Okay, perfect. Sorry, I thought that was a question.
Difference, no, because right now I don't really have that, and it's a temporary order, and that's where you guys either have to reach some sort of agreement on what's going to happen, or you find out in discovery if there's allegations, and hopefully the parties at least had somewhat of an idea of what everyone was having and making. So, all right. What the court, so a couple things. Mr. Huberto, just to point out, your client's pay stubs, the most recent pay stubs, it shows that he has made $80,000 in the first 6 months of this year. Now, I recognize that is the gross, but he has made $80,000. That is $160,000 in a 12-month schedule, maybe a little less because it's not quite 6 months. And obviously, what payment he got in the 1st of January oftentimes includes a week or so from December. And at the end of the month or the end of the year, the last 6 months from July 1 through December 31st, his last paycheck is going to end up being the whole year really ends up being from the very end of the year before to the week or so of the year of, just because of how people are paid, So, but he's made $80,000, which would probably equivalent out to like 155 on a full year, because recognizing it's not quite 6 months. If you took all the pay stubs and saw when that first pay stub in January included some of December. So we're a little over 6 months with the 80,000, but that is a little different than the 128 that he says he's making. I do recognize when you look at his pay stubs, some of them are quite a bit bigger than the 6,700. He made 4,000 in 1 2-week period. He also made only 27 or 2,800 in a 2-week period. I do recognize that. I'm just pointing out to everyone there's not enough money to go around. So mom's not going to she's going to get the child support. She's not going to get any maintenance, and I'm not going to order any attorney's fees paid. There's just no way to make that happen with dad paying all of the bills, which I'm going to have him continue to do. And at least for right now, I am not going to order any additional payment back from mom. But I will give dad the opportunity to revisit this in a few months if he wants. And mom needs to be looking at getting a job, or I'm going to have to order her to help pay some of the bills. And Mr. Swenson, we need to put in the order that as soon as your client gets a job, she needs to notify dad. And if I find out that she's had a job for 2 months and hasn't notified dad, we're going to have a problem. So
Understood, Your Honor. Thank you.
And I want to let the parties know that as soon as mom gets a job, she's going to have to pay some of these bills. Okay? If you guys can't agree on it, I guess come back to court. But I'm trying to give a little bit of some guideposts. Mom's going to have to help pay some of those when she gets a job. But right now, she doesn't have one. Dad has to support her. I'm not doing anything. But like I said, Mr. Huberto, in in what is today? All of July, all of August. If by September 15th she doesn't have a job, Dad can come back in, and Mr. Swenson, I'm going to have something. Or I'm going to start making her pay some of the bills. You know, okay?
Yeah, what day was that, Your Honor? I'm sorry, it cut out for a second.
Oh, sorry, September 15th.
September 15th. Okay, thank you.
Understood, Your Honor.
Okay. Any questions? Anything I left out, Mr. Huberto?
No, I think I caught all of it. We can we just put it on for next week administratively, just as a backstop to make sure we get a temporary order filled out?
Sure.
Because I'll probably need to revise the order itself of child support, so that way it doesn't have the deviation. The one I proposed, of course, has the deviation.
Well, actually, if you
could cross it out and put the number in it.
The most revealing part of the ruling is not the child support amount, but the employment expectation placed on the mother. The judge refuses to treat unemployment as an indefinite condition. Instead, it becomes a temporary circumstance with an expiration point.
Well, I think it's in where it doesn't even, it shows a standard calculation and it shows it at the 1498. Yeah.
Okay.
Says 14. I will just strike through paragraph 9, the deviation.
Yeah, paragraph 9 is the issue. Yeah, good point. So if you strike up paragraph 9, that solves the order of child support. I think it provided a proposed temporary order as well, if Your Honor is willing to cross off, or actually, I'm not sure if there's anything for you to cross off other than right in the end. We can come back at 9:15, but I suspect with Mr. Swenson, I get along well enough that we can probably note this up without you having to interlineate that after September 19th. But
okay, and Miss Maggard, anything on the order of child support? If I just cross through the deviation, leave the standard calculation as the 1498, sign it. I do need to put on past due amount. I need to strike through as of 8/1/26, no parent owes, and just put
Reserved.
Does that work for the state?
Yes, Your Honor, that was going to be my suggestion, as well as Ms. Wilson needs to notify DSHS of this child support order, because that will be income attributed to her. And I will be monitoring that.
Okay. So I'm signing the child support order and worksheets. Mr. Swenson, anything else from you on the child support order and worksheets?
I don't think so, Your Honor.
Okay. 7/10/2026, I signed the child support order and worksheets. On the temporary order, I will just put in here order of child support, household. The vehicle, I'm going to strike through and put petitioner for right now. It is still the petitioner that's paying the Sienna. And I recognize issue under other temporary orders. I'm going to write mother to notify father of her obtaining employment within 3 days. Okay. I will also put after September 15th, 2026. Either side may note a motion to evaluate financials. And I do need to put in here too, employment after December 15th, no motion. Either side may note a similar motion after mother obtains employment if no agreements reached. So counsel say they work together well. So mom gets a job, you guys at least talk, see if you can arrive at something that you can agree to for the financials. If not, get it in front of me. Like I said, Mr. Swenson, I'm gonna, mom starts making even minimum wage, it's a couple $1,000. There's gonna have to be some sort of allocation and allotment. I realize you guys might not ultimately agree, but if you can, hopefully you can. So,
yeah, we appreciate the direction.
Okay.
Your Honor,
Yes.
would you be willing to add to the order that the mother must notify DSHS of the entry of the child support order?
Sure.
Thank you.
Mother must notify DSHS of child support.
The judge's review of the income records highlights an important courtroom principle that many litigants underestimate. Financial declarations are only part of the picture. Pay stubs, tax documents, bonuses, and employment history can completely reshape how income is viewed. Rather than accepting either side's preferred calculation at face value, the court carefully examines how earnings fluctuate over time before deciding what is actually sustainable. That prevents short-term spikes or isolated numbers from controlling long-term obligations. The ruling also reflects practical reality instead of theoretical fairness. Once the judge concludes there simply is not enough money to satisfy every request, priorities become unavoidable. Supporting the children comes first, while additional financial demands receive far greater scrutiny. The closing portion of the hearing shows why experienced judges build future review points directly into temporary orders. Instead of pretending today's decision solves every issue, the court creates a structured process for adjustment as circumstances change. Employment, financial disclosure, communication requirements, and future motions are all connected through clear conditions. That reduces unnecessary litigation because everyone knows exactly what event will justify returning to court. The judge also encourages cooperation before additional hearings become necessary, signaling that negotiation remains preferable to repeated courtroom battles. Temporary family orders work best when they evolve alongside changing facts, and this framework gives both parties a roadmap instead of leaving them guessing about what happens next. The final commentary surrounding the case reflects why public reaction to family court often becomes polarized. Large financial figures naturally attract attention, but raw numbers rarely tell the complete legal story. Throughout this hearing, the court repeatedly focused on balancing competing obligations instead of rewarding either side outright. That distinction is easy to overlook when support payments, public benefits, and household expenses all overlap. The lasting takeaway is that temporary family court decisions are rarely about declaring winners and losers. They are designed to preserve stability while the larger case develops through discovery and future proceedings. In that environment, documentation, credibility, and demonstrated effort consistently outweigh dramatic claims, making preparation far more valuable than emotional persuasion.